This conference will now be recorded.
Hi, my name is Janae Moxie, and I'm an associate in the Atlanta office of Nelson Mullins, Riley, and Scarborough. I'm here with my colleagues Franklin Chow, who is an associate in our New York office, and Dan Sanders, a partner in our Atlanta office, to talk today about COVID-19 and our clients' contracts. This presentation or training webinar is part of a broader set of trainings being presented in connection with the Law for Good Government's COVID-19 Small Business Clinic. And so we're very excited to be a part of this and excited to share our knowledge and hopefully help the clients that will be a part of this. So as a brief overview, just waiting on my next slide. As an overview, again, we have our two colleagues, both of whom have extensive experience, one with contracts and contracting in general and doing this on a day-to-day basis, and then two, and more recently, have experience dealing with the contract issues brought on by COVID-19. Both are experts in this area, and I'm very glad to have them both here. So as a general framework, we'll first start with, what does force majeure mean? And I say this in the context of this presentation, we're really focused on COVID-19 impacts specifically. In connection with the New York training, the folks from Cleary did a really great kind of foundational background presentation on contracting issues more generally, and I would encourage anyone to watch that just as a refresher anyway, because it was great, almost bar review style, foundational contract information. So here we'll be focusing on really mostly on force majeure clauses and in the context of COVID-19 contracts. So we'll discuss in that context the business impact of COVID-19 and then specifically commercial contracts, since that's probably most of what clients will be bringing to us. And then moving off of force majeure, we will turn to defenses other than force majeure that might apply when that's not necessarily an option, the clause doesn't work for our purposes, or it's just not there at all. We'll move then into practical considerations for our clients and their current contracts and those issues, and then also moving forward in kind of a post-COVID-19 world. Lastly, we'll just wrap up with final points on all of that information, and then general advice for working with these clients and really helping them and giving them practical advice that works in this context and works in the context of everyone just trying to kind of figure things out and work together to make everybody's life easier. So with that, I'll turn it over to Dan to get started on force majeure.
Great. Thank you, Janae. And it's my pleasure to participate today and hopefully help all of you who are listening. Wow, force majeure, who would have thought even a few months ago that this would be such a hot topic today? Most of us haven't worked on force majeure since law school or the bar exam, but we probably recall generally that force majeure are unforeseeable circumstances or events that prevent a party from fulfilling their obligations under a contract. You also may recall that force majeure in the French language stands for superior force, and really over the last decades, most of us have seen force majeure in the context of earthquakes, hurricanes, tsunamis that have tended to thankfully be relatively short in duration and usually impacting only one party to the contract. And unfortunately, as we've seen in the last weeks and months with COVID, it's a much broader, devastating impact, and not simply to one party, but often to both parties to the contract. Can you change slides? So at a high level, you may recall that the World Health Organization declared COVID to be a global pandemic on March the 11th of this year. And just a few days later, the President of the United States declared a national emergency. And since that time, and due to the rapid spread of the virus, the federal government and state and local governments have been accelerating efforts to prevent and slow down the viral transmission to protect all of our health and the safety of the public. This has taken the form of numerous government orders and declarations that we read every day in the news, And these actions are obviously causing widespread commercial and economic disruption on a scale which is extraordinary, unforeseen, and unprecedented in our lifetime. And as it relates to what we're talking about today, this has also put force majeure clauses in our business contracts into the spotlight in a variety of contracts. So knowing that force majeure generally are overpowering, irresistible forces, acts of God that are out of the control of the parties to excuse performance, when we're going to analyze these in the different contracts that you may be looking at, as is often the case in legal context, the devil is in the details. I've been practicing law 30 years, 20 of those years in-house as Michelin's general counsel, and I can tell you that force majeure clauses, in my experience, and I think in the experience of the colleagues on the call and in our firm, are probably one of the least negotiated provisions ever. I can't actually recall, maybe with the exception of a new construction site for a plant, ever actually negotiating with the other side the details of a force majeure clause. But, with COVID today, we find ourselves looking at those clauses really almost on a daily basis. Next slide. And in that context, you can imagine that the impact is across all types of contracts. So a few examples: manufacturing contracts, supply contracts, purchase agreements, sales contracts, franchise agreements, and travel and hospitality contracts. Of course, there are many more examples. And as I mentioned a minute ago, I think what's most unique about COVID, in addition to just the broad impact, is that it really is affecting the ability of both parties to perform. So whether you're a buyer, a seller, a landlord, or a tenant, unlike what we'd seen in the past, both parties are grappling with the impact of the force majeure event, in this case COVID, on their ability to perform. Advance the slide. So as we all recall from law school and bar exams, the clauses generally set forth the limited circumstances under which a party may terminate or fail to perform without liability due to the occurrence of an unforeseen event. So what we thought we'd do, you can advance the slide, is show you a few examples. The first, and I won't read it to you, I'll just leave a few seconds for you to read to yourself, but the first example is a common commercial contract provision that is mutual, meaning that it's applicable to both parties. I'll take just a few seconds and let you read that for yourself. And Janae, you can advance it. And the second example, essentially the same language, but in the context here of applying only to one party, in this case, the seller. Give you a few seconds to read that. And obviously there are going to be all types of different force majeure clauses and different types of language, but we think these are two that we can just show you for illustrative purposes that are quite typical. You can advance the slide. The other thing you're going to see in most contracts are what we call catch-all provisions. Many contracts contain these catch-all provisions. For example, any other clause whatsoever beyond the control of the respective party that may appear to cover any unforeseen event. So whether you're talking about the force majeure clause specifically or the more general catch-all provision, courts generally interpret these clauses, or have in the past, narrowly, and typically do not interpret a general catch-all provision to cover situations not specifically enumerated in the balance of the clause. It'll be interesting to see as we go forward how, for public policy or other legal reasons, courts may decide to interpret force majeure or catch-all provisions more broadly, just in the context, again, going back to the widespread devastation globally. A last point to keep in mind is that some force majeure clauses specify that they only apply for the length of time of the actual triggering event. And again, that's going to be something that will be very fact specific and evolving as we go forward related to what is the quote duration and specific impact of COVID. Those are going to be difficult fact-based issues. Go to the next slide. And so sort of stepping back from these first introductory slides, what we're seeing is that really the first analysis is when you have a force majeure clause or issue, the factors affecting whether the force majeure clause will excuse non-performance are essentially three. First, did the event fall under the contractual definition of force majeure? Second, was the risk of non-performance foreseeable and able to be mitigated? And third, was the performance truly impossible? And as you're working through those three questions, it will be important to look at the choice of law provision in the contract. Most contracts select the state law that will apply to the analysis. And what we've seen in the last weeks and months is that there is a great variety of state law difference. So if you take New York as an example, on one extreme, they tend to be very strict in the interpretation. Other states tend to be very broad, and so that will be an important element to reflect on. And so what I'll do now is turn it back over to Janae, who will dig in further on the additional issues on the force majeure and also discuss some contractual defenses that might not come to mind because they're not specifically related to force majeure, but that probably will apply in contracts where the parties are reflecting on how to postpone or avoid certain obligations. And Janae will touch on those as well. So Janae, I'll hand it back to you.
Great. Thanks so much, Dan. And as Dan just referenced, and it kind of on that first slide, the first question is, does the event fall, if there is a force majeure clause, does the event fall under the contractual definition of force majeure? And so the first place that people are looking is, does this clause specifically reference a pandemic, an epidemic, serious illness, plague, disease, or outbreak? And frankly, a lot of them don't, because most of us haven't thought about these issues popping up. Before this all happened, it wasn't really top of mind. So that's going to be the first place you go. And then even if that kind of language is in the contract, then who determines if it's a pandemic? Before the World Health Organization declared COVID-19 a pandemic, a lot of people were asking, well, is this force majeure clause triggered? Because, they're feeling the effects of COVID-19, but if it's not officially classified a pandemic yet by whether it's the World Health Organization or the federal government or whoever is the designating factor, we've all discovered can be a confusing question, then, even if that language is in there, it might not be triggered. So that's the first. And then again, as Dan just referenced, maybe that only applies as long as the pandemic is actually going on. So, or as long as there's a declared pandemic. So another consideration we'll see as time goes on. The next issue is, does the force majeure clause refer to civil emergency or national emergency or government acts? And this, again, may or may not, but here, this will go both federal, the federal government declared an emergency. Does that trigger this force majeure clause, or are government acts on a state-by-state basis, the Georgia shelter-in-place order, or, when we had one, or other orders, do those things fit with the language of this clause and qualify as government acts or, civil emergency things that would trigger this clause? So going into those kind of state-specific issues, we'll lead off with the Georgia government acts. And actually just yesterday, a new act was issued, a new executive order was issued, but actually was pretty much the same as the previous one and added added a lot of detail about reopening. But essentially, in Georgia, the executive order that Governor Kemp issued on April 30th renewed the public health state of emergency, but it really only requires vulnerable populations to shelter in place through June 12th of this year. So, initially when COVID started, we were getting a lot of questions about, am I subject to the shelter in place order? How do I deal with this? Do I have to shut down my operations? But a lot of that is gone now with the exceptions that we'll get to in a bit. So then, moving on to, the fact that that expired, and now we're kind of moving into a new phase of businesses being permitted to reopen and, potentially losing, if there is even a government acts clause or language in that force majeure clause, kind of losing that protection is now becoming an issue for people seeking kind of force majeure coverage. For some businesses, I'm sure, a lot of the small business owners will be seeing are going to be restaurant owners. So social distancing rules are still in effect. In Georgia, at least, large gatherings of more than 10 people still prohibited unless there's a 6 feet of distance enforced. But a lot of businesses can't do that or can't function that way, or, they're still going to have fundamental kind of contract issues. So that could still be an ongoing issue for most businesses, but especially for restaurants and businesses like that. And then lastly, certain businesses are still required to remain closed. They're limited, and I'll give a kind of overview caveat right here. All of this information is kind of shifting sands based. So, tomorrow there could be a new executive order where this might change. So one overall comment here is to make sure you are abreast of the latest law when you have been scheduled for a client session, just so you know, because like I said, it's always changing. North Carolina, executive order issued on May 5th. Again, we're moving into the reopening phase. So, some of our clients may be losing cover for government acts language in their force majeure clauses. And further, there's a distinction between essential and non-essential businesses. So that will still be a careful analysis of, what's required to remain closed or to review those shelter-in-place orders more carefully. And again, in North Carolina, social distancing rules are still in effect. So how does that affect, our clients' coverage under these government acts clauses and these force majeure clauses? Again, all this is fact specific and will need to be carefully reviewed. So this catch-all language that Dan referenced, does the clause contain catch-all language that might create uncertainty as to whether this will be interpreted narrowly or broadly? And as Dan referenced, often the answer is narrowly. That language is going to be possibly not that helpful to our clients. So regarding acts of God, for example, Georgia law is silent with respect to whether pandemics or viral outbreaks constitute acts of God. And the case law definition is that acts of God must not be caused by humans, can't be reasonably predictable or avoidable. But it's still unclear if that applies to pandemics. So it's likely that a number of cases are going to end up in front of the courts that will give greater clarity here on whether a pandemic is an act of God, or maybe there will be the state legislature will clarify, but for now it's very fact specific and will be based on the accompanying language in that force majeure clause. So moving on now to jurisdictional differences. Again, courts interpreting these clauses and other defenses to non-performance recognize that there's an issue between enforcement and excusing when there are exceptional unforeseen circumstances like COVID-19. So we'll go now into the state law variations, specifically, of course, in Georgia and North Carolina. So starting in Georgia, and I put one of my favorite Georgia peaches here. I know that she's controversial, but still represents us. Force majeure clauses are construed very narrowly under Georgia law. And so when there aren't any specific events listed other than acts of God, Georgia will interpret this clause consistent with the code, which I just described kind of what's in there. But also, a contract doesn't need to include a force majeure provision for a party to invoke act of God as a defense. And for a little more on this act of God, a case in Georgia, Holder, noted that Holder bore the risk of late delivery because it wasn't due to any of the reasons set out in the force majeure clause. So as you can see, if it's not in there, or, Georgia courts have held, if it's not in there, you might, that client seeking that protection might be in trouble. So again, narrowly construed. North Carolina law, again, well, actually in this case, there isn't a whole lot on force majeure clauses under North Carolina law. So we actually put here more general reference to just the idea that these clauses are narrowly construed. And it also goes back to kind of basic contracting principles here where, the parties draft their language in theory, and that language includes the whole agreement. So courts are going to go by what the parties agreed to do. And if the language doesn't say it, then you might not get it. Again, all this could change based on the court cases that come through, based on legislation that is enacted on a state-by-state basis, but this is kind of the state of things right now. Moving on to defenses to contractual non-performance when, one, the force majeure clause isn't triggered, or two, there is none. So again, here, even if there's not a clause, we're going to look to impossibility, impracticability, or frustration of purpose. So impossibility. This may apply when it's objectively impossible for our client to perform this contract. So if your business was completely shut down and you were supposed to fulfill some orders, but it was illegal for you under your state's stay-at-home orders, you are an essential business, you were a restaurant, and you couldn't, then there was impossibility. But of course, it's not going to be impossibility for every contract. We're not going into leases right here, but that might not apply in a lease context. But for certain commercial contracts, if it was objectively impossible to perform, then that is going to be a defense to look to if force majeure isn't working. Now on to impracticability. So this is where some unforeseen event outside of the party's control took place after the contract was signed and made it commercially impracticable for one of the parties to fulfill its obligations under the agreement. And it's important to note that impracticability only applies when the contract is for sale of goods and governed by the UCC. So, determination of impracticability focuses on, the party's expectations, again, under this objective standard. So I'm talking in terms of courts right now, but as I'll mention at the end, the ultimate goal is not to work through these things in court. But, under an objective standard, does the party's expectation match what can be done under this contract? And so ultimately we'll discharge a party's duty to perform where the event was unforeseen, performance is impossible, or the non-occurrence of this event, COVID-19, was a basic assumption on which the contract was made. And again, using an objective standard, objectively, none of us saw this coming, 6 months ago even, or the impact of it. So that will be something to look to and consider. Next slide is frustration of purpose. And I'll note here that frustration of purpose is neither explicitly recognized or rejected under Georgia law. And it applies when unforeseen circumstances or events preclude the achievement of the purpose of the contract. And so a classic example of this is that, have it right here, that a commercial lease to operate a tavern entered into before Prohibition. So it doesn't even, there is no purpose to me doing this thing anymore. And so, again, because it's fact specific, I can't pull from the top of my head a scenario that would lead to frustration of purpose here, but I'm sure that many of our clients will surprise us and outline all kinds of crazy circumstances that have happened due to COVID-19. So this is another defense to consider. And I'll now turn it over to Franklin with more information on these types of practical issues to consider.
Great. So thanks, Janae. Do we want to advance the slide to the next? There we go. So, right. So the first thing you want to consider, of course, is, the contractual notice requirement. I mean, there's nothing worse than having the out of force majeure built into your contract and then not being able to exercise it because you missed the notice window or the notice period. In a lot of states, including Georgia, but what's required is seasonable notice, so action taken seasonably within the reasonable time frame. And that time frame depends on the nature, purpose, and circumstances of the action. So, if in a standard, like let's say services provider contract, there's a 30-day out, that's market, and that's what's reasonable in the time frame. I mean, it's a very what's the issue with these are they're very time consuming and fact sensitive analyses. So and there's no really one size fits all kind of provision for that, and you really need to go into the fact specific analysis of how what constitutes seasonal notice. So if we could go to the next slide. Great. So right. So let me just caveat this by saying, like insurance is an extremely technical area of the law. There's, state commissioners of insurance, and because of, Dodd-Frank and because of HIPAA and the ACA and the Affordable Care Act and whatever, the federal government has largely historically been kind of in the outskirts of the insurance regulation business. They're really stepping in too, and some of those insurance clauses may not necessarily be at issue in force majeure, but it's important to know that insurance is highly regulated. It is subject to both state and sometimes federal regulation. So this is not really a primer on insurance, but generally speaking, I mean, insurance is a really good way to determine whether or not force majeure apply your coverage under a force majeure scenario, specifically if you have like business owner's policy or a business interruption insurance, which are designed specifically to protect against temporary closures of businesses, and that could be due to any number of reasons, including governmental action, which is kind of what a lot of the COVID-19 crisis will fall under. You could also rely on a commercial general liability policy or an umbrella policy if you have one. Again, there's a lot of technicality in this area, specifically when it comes to commercial general liability contracts and about covering for, typically those cover for, bodily injury on premises or other types of personal injury types of accidents. And they're limited to the law of negligence, and they don't cover, what lawyers like to call the economic loss theory. And they're these may or may not be applicable to you, but it's important to understand what kind of insurance coverage your client may cover, or may be covered under. And even if these sort of insurance policies aren't really your wheelhouse, having that conversation with the counterparties is always productive, especially if it's, because these business relationships are what's reduced to writing isn't often what is really, contemplated by the parties, and having that context, having that discussion with counterparties is really crucial to understanding, what you're doing with the commercial contract beyond the four corners of the document. So if we can go to the next slide. Great. So, right. So, I mean, Dan and Jenna have really covered this a lot, and I'm not going to beat a dead horse here, but basically, when it comes to force majeure clauses, was the event that took place, unforeseeable? I mean, I would say honestly that before March 11th or whatever it was, that global pandemic closing down every aspect of commercial activity in the United States was probably unforeseeable. But now, it's different. The circumstance now is that it is sort of foreseeable. So you want to now analyze what was the unforeseeable for the parties at the time of contracting. The other thing is that increased cost or financial burden is usually not itself enough to exclude performance. So if you're going to be trying to get out of a contract due to force majeure, and you're looking at, I have to sell these goods at cost, or I have to sell even these goods at a loss, I mean, that alone enough is usually not enough to exclude performance under force majeure. I mean, you have to come up with circumstances that are not financially impractical, but financially impossible. And that's a really different distinction. So, of course, if you're using, if you're a party invoking force majeure, you also kind of a duty to mitigate. So let's say you're a supplier and you have, your contractual obligation ends upon the delivery of the service to the manufacturer, and your delivery driver gets sick with COVID-19. I mean, it's not enough for you to say, hey, my regular guy is sick. You need to go out and, procure another delivery driver, procure maybe a common carrier type of situation if that's something that their contract allows. It's really on you to exhaust other alternatives before you kind of point to force majeure and say, hey, listen, I'm out. So if we can go to the next slide. Being a lawyer in practice, it's really interesting because you have these clients who come to you reactively, sort of like, oh my God, the bottom has fell out of my business, and now you're kind of there to clean up the mess, and that's always a difficult place to be in, but you can still help, and part of the way you can help is by evaluating the contracts that are in front of you and determine whether or not force majeure applies. Evaluate the effect of these notice and timing windows. Like I said before, I mean, it's so important because if you have an out of force majeure and you're not giving the appropriate notice, 45 days notice or something like that, and then you give notice on day 47, you just open up your client to liability because you're not prepared to address the timing consideration. And of course, a lot of this can be compounded by the fact that clients don't give you the documents in time for you to exercise these notice windows. But it's important to keep yourself abreast of what the contract is, and every contract is very unique and it's subject to the unique situation between the parties. I think it's so interesting because contract law is kind of whatever you want to do, but you need to make sure that whatever you do is within the document within the words of the contract, so you understand kind of what's going on in the contract. And a lot of this, common law force majeure stuff could even be, written off by the parties or twisted in ways that, you don't even think of and don't really make a lot of sense or really make a lot of, they don't really comport with, kind of the general overview of how contract law you think works. But as long as the parties have, discussed the allocation of risk accordingly, I mean, they will be binding on the parties. So it's important to kind of be aware of the situation, between the parties. And if we go to the next slide. Great. So, right. So like I said, I don't know if anyone listening on the call is a litigator, but I mean, bless you guys. You guys are the guys who clean up after our transactional guys' messes. But if you have the luck of having a client who's proactive and getting you the materials or getting you the kind of like business operations lay of the land before things kind of blow up, I mean, there's a lot of things that you can do to kind of protect or mitigate the exposure of risk to your client. Like, for example, I mean, you always, as I said before, you always want to proactively evaluate your client contracts. What are the touch points between your client's business and how it interacts with the world? Who are their counterparties? Who are, the third parties that are may not even be in privity of contract with these parties, but are, out there in the periphery? That's like your insurance carrier. That's like your vendors. And what are the ways that your client interacts with these people, with those entities? Second, document. Always document. I mean, whether you're using force majeure as a shield or using it as a sword, keeping detailed records and tracking the spread of the virus. And, the virus, on day, 6 infected, 10 people in our workforce, and 10 people of our workforce is, like 20% of who we employ. And that could mean a material difference in how your business operates and could prove the causal nexus between the virus and what you're experiencing as a business, and how it affects your operations and whether or not you can or cannot, feasibly continue operating. The actions you take to mitigate the effect of counterparties, again, as I said, that's classic risk allocation kind of thought process. And again, if you can use force majeure as a sword to extricate your client from, a contract that no longer makes business sense, I mean, that's a great way that you can save your clients tons of money and tons of effort and expose them to less risk. But it only makes sense if you're proactive in evaluating your contracts and evaluating, not only the contractual relationship, but also the business relationship between your client and the client's counterparties. So let's go to the next slide. Right. So, I mean, this is my favorite part to talk about. I mean, if you're negotiating new contracts, I mean, this is a totally. Oh, sorry. Next slide. Oh, great. Okay, good. So, right. So, with regard to any new contracts that you might be contemplating, right? I mean, um, always consider the contractual provisions impacts on the performance and consider applicable law. I mean, this is all choice of law stuff. It's really important that you kind of make sure that you're putting the jurisdiction of your client's business in the legal jurisdiction that you're comfortable with enforcing, or if 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 not, then comfortable with the jurisdiction and how it treats um, your client's business operations. So, uh, right. So when negotiating a new contract, right? Like now, again, as I said before, like now, sort of the pandemic is, you got to say that that sort of thing is foreseeable now, and I bet you lawyers around the world are now working around the clock to integrate that into their new contracts. Triggering event for non-performance. I mean, I don't know. I don't, as Dan and Janae have both alluded to. I mean, I don't really take any stock in this sort of catch-all provisions of force majeure. I think that really what you need to do is you need to lay out every single thing that you think could possibly happen. And weather-related incidents are actually really interesting, because that's what Act of God was kind of written to cover. And the weather-related incidents are maybe about a dozen, and you can look them up on Wikipedia and say, these are the weather-related incidents. So it's a finite number of incidents, and anybody who's looking to include that, it's foolish not to include every single incident that's listed on Wikipedia. So, I mean, that's a really easy way to do that. Governmental response, I mean, that is built into a lot of contracts, and that's very interesting, because that is kind of, I think, the crutch that a lot of contracts will be enforced under the force majeure provisions, because the act of God thing, it just is not going to cut it. Let's go to the next slide. Right. So consider, whether or not avoiding force majeure altogether is right for you. I mean, I always say that force majeure gets you into the land of non-performance, and the whole point of these contracts is to get performance. And you can look in, case law and things like that, and it just shows you that, the performance of contracts and specific performance is almost never awarded. So you never want to get into that world of non-performance. You want to stay in you want to stay in not force majeure land. And a lot of times, even insinuating that non-performance, could happen down the line, is it could destroy business relationships. And you really need to think, the farther down the supply chain goes, the more specialized the product is, right? Like mainframe computers, for example, like IBM has cornered that market for 30, 40 years. And, you don't want to destroy your relationship with a vendor who supplies the product that you really can't do work without, because no one else supplies that product. So, in a lot of cases, what you really want to do is defer performance. And sometimes deferred performance is acceptable, and that's fine for the parties. And what I'm saying is that, you can get to where you want to be without getting to the land of non-performance. And you want to make sure always that you draft contracts around the business relationships, and make sure your contract doesn't dictate your business relationship. So why don't we go to the next slide? Right. So these are some, throwaway things, and you guys can look at these on your own time, but termination for convenience. I mean, these are sort of things are all things that, amount to excusable non-performance. So, I mean, we want to get out of the world of non-performance in general. So we can, a lot of what we do, next slide, please. So a lot of what we can do is like, risk allocation exercises is really what you want to do. And again, I don't want to harp on the insurance provisions. I mean, that's, as I said, very complicated stuff. But, if you're looking at how to allocate risk, I mean, between the parties and between the parties, so like, adding your counterparty to like some sort of business continuity plan, and making your counterparty privy to the BCP and how that affects business operations. Or if you want to bring in third parties, and that really does go into like shifting risk to insurance carriers and shifting risk to other individuals who are not in privity with the client and the counterparty. So if we can go to the next slide. And I think this is my final slide, but building risk into the pricing model. I mean, that's really a great way to do it. I mean, using pricing credits. So to adjust for cost. Like, if you perform or if you don't perform, you get a certain amount of pricing credit. So if you don't perform on time, we'll reduce the invoice number, and we just won't pay you as much. Or if you do perform on time, or if you do perform better than on time, like faster than we thought, then we'll actually give you some more money. And incentivizing those relationships between the client and their business partners, I mean, that really goes a long way to solidifying your contract relationships in times of distress, because you can go into a COVID-19 situation and say, hey, look, like, listen, we're in an unprecedented time when everybody's being impacted by this, but listen, we've got like 10 years of goodwill built up over the time we've operated with you, and all these credits for performance and non-performance and things that we haven't cashed in on, and we can cash in on them now to further the business relationship, because we think you're a valuable partner, and just right now is just not a good time economically for us. I mean, that's totally, a great way to handle that. Deferred payments are, usually the norm, usually for, if you're delivering services and then you get invoiced later. Deferring payment always gives you, if you're client and you're deferring payment, that always gives you the kind of financial edge of not having to pay for something if it doesn't come in. And then there's, of course, like holdback provisions, like an extension of terms for payments already rendered. So, if you're not getting the service that you think you are deserving, or your counterparty is kind of withholding a little bit, well, then you can say, okay, well, we'll extend the term of the agreement, or we'll extend the payment period of the agreement, or something, to give you guys time to catch up. And all of these techniques, what they mean to do is to get you and the client and the counterparty to keep performing, even if that performance is reduced, even if that performance is de minimis, and even if payment for that performance is, like delayed or somehow deferred. The point is to get the clients out of the world of force majeure and into the world of imperfect performance, but still performance, so that these business relationships can be preserved. And that's, I think, it for me.
Thank you so much,
back over
Franklin.
to Jeanette.
Thank you. So I'll just wrap up and probably touch on a couple of the points that Franklin touched on with respect to force majeure, and then generally with clients. Skip that slide. So just in terms of working with clinic clients, one thing, I think the main thing is to listen. I don't know if I'm sure that others have experienced this as one of the only lawyers that someone that knows, where maybe you're getting a lot of calls on your personal line, where people just want to talk about issues that are deeply affecting their lives. Aside from, it's all kind of melded together, but people's lives are in upheaval. Business owners do not know what to do right now. And so, as part of this clinic, the huge benefit that we can give to people, especially as corporate lawyers, is to listen first and just be here to really understand their problems. So moving on to the second one is understand their business. These sessions will be fairly short, as I understand it, but that's no reason to not kind of get your arms around what their business is. And then as you're listening, understand what their objectives are. When you start talking, instead of listening, speak plainly, and don't use too much legal jargon, legalese, because that is going to probably overwhelm the client more. An overwhelming and already overwhelmed client is not the goal. The goal is to provide some measure of, one, of course, help, and then also comfort. So the next point here is to be creative. A lot of us lawyers around the city, especially for corporate lawyers, we come up with creative solutions for our, typical clients all the time. And, that's how we went to law school. That's how we paid the big bucks. So we are creative people who can think through a lot of difficult issues. So I feel like now is really our time to shine. But as usual, the lawyer caveat there is don't be so, this is unlimited engagement, and we can't know everything about their business as much as we should go and look beforehand and at least understand what they're doing, what they're going through. But, we do have to emphasize that this information, this advice is being given in this kind of 45-minute or however long it might be, vacuum. And also, as I mentioned earlier, given in connection with laws, regulations, circumstances that are changing daily. Every part of our lives is changing daily. The world looks completely different and it's changing every day. So we do have to be mindful of that, but we don't, my goal is not to give that lawyer response of, well, it depends. I think that we should be able to, using these kind of basic contract principles and an understanding of how COVID-19 is impacting these contracts, be able to give creative advice, but of course make clear that it is limited to, this conversation or this, what the client has told you on that day. So in terms of advising, as Franklin mentioned before, it'd be great if every client had every document or every contract all together, but many of them won't. So just advise them to gather their contracts and assess obligations under those contracts. And, maybe we're only helping them with one major contract that they have, or maybe they have a bunch that are all combining to make life difficult. But in any event, they should have that paperwork together for you to at least be able to take a quick look at or give advice in the context of their actual contracts. Another thing is, Franklin again mentioned notice earlier, make sure that you understand the notification requirements under those contracts and let the client know about those notice issues so that they don't have another problem on top of their, meeting this burdensome contract requirement. We don't want, potential additional breach there. So, all right. So the next, again, make sure you understand their business. Sorry for that repeat. And then back to documentation, make sure that they document all their communications with the other party. So bring their documentation to you and then try to do things via email. If it wasn't done via email, take some notes after a call with the other party just to make sure that you have a kind of or the client has a concrete understanding of their obligations or what's been discussed. If they came to some phone agreement together, like, oh yeah, everything's cool, you can do that, have them write it down so that they, later on, maybe it wasn't in writing, but at least they can know the kind of specific terms that they came to with the other party. I think this is my last point. Our goal, given the kind of limited engagement, is to help clients be practical and really to encourage them to talk and work through these issues with their counterparties. Our goal is definitely not for our clients who are already in this very difficult situation to seek a judicial process that is just going to hurt everybody. As Franklin mentioned, a lot of these, our clients and a lot of business owners have valuable relationships. So the goal is not kind of a scorched earth approach to, in the spirit of, okay, well, it says this, the force majeure clause says this, so you definitely should kick them to the curb, not pay them, whatever. No, I think the goal is more to really talk through, one, what do they want to do? What do they think? What's their relationship like with that counterparty? What have they done in the past? What are the issues right now? Is it practical for them to be able to overcome them? What does that other party need? And, given your standing relationship, what might they be willing to accept? And then also, what's your leverage? Have you had goodwill the whole time? So will it be easy to come to a good understanding? These are all things that I think in a practical sense to talk through with these clients. That is all for us. The goal here, again, is to give a broad overview of contract issues that we have seen pop up in the past few months. For a clause that most people didn't even really look at and was very boilerplate before, it is the star of the show now. So, all of this information is developing and changing all the time, but I do believe that, with some tools and keeping abreast of the newest developments in your state, that we can really be great help to our clients. So with that, I'd like to thank Dan and Franklin again for being a part of this. And please do, all of our information is at the beginning, and feel free to reach out to us via email if you would like to talk through these issues more. And then we also have, the firm has a great COVID-19 resources website that I have been using a lot just to familiarize myself with all the new laws and, circumstances that, there's a whole new body of law developing. So it's just helpful to be able to stay on top of it all. So thank you all for your time. And again, we're very honored to be a part of this process and excited to help these clients.
Yeah, thank you.